Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 3rd. The time's 9:30 a.m. With us today are Commissioner Bobby Janecka and our General Counsel, Mary Smith. I'm John Neerman. Most of the participants in today's meeting are joining us virtually, so I'm going to remind folks to please keep your microphones on mute when you're not speaking. And if you're here only to listen, you can also watch the agenda online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration is now closed, but if you'd like to address the Commission on a particular topic, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate that request. For those who are making presentations, please wait to begin until either I or our General Counsel have asked you to do so. And remember to check your line, make sure it's unmuted. With that, I'd like to thank everybody for being present today. Ms. Smith, I think we're going to take up old business item 1 with the enforcement docket, so I'll ask you to please call new business item 1.
New business item 1 is the application by Van Ruyten Dairy Partners for a major amendment to Texas Pollutant Discharge Elimination System permit number WQ 0003290000 for a concentrated animal feeding operation. The parties have been notified that the commissioners will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
Thank you. So for the benefit of those who aren't familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has done so, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And Commissioner Janecka, we have a single request on this item. Monica Warden submitted several comments beginning in October of last year, and I think she has met the procedural and substantive requirements to be entitled to a contested case. And for me, it was not immediately clear that she had actually lodged a proper request. And her letter on November 12th of last year, which is styled as a request, actually, in my view, didn't meet the requirements. It's not adequate as a request because she failed in that letter to articulate a personal concern. However, I think her comments in October of 2020 did articulate a personal concern. And even though she could have been a little bit more explicit in the letter, I think there's enough there to signal that she was indeed requesting a hearing. So I'm inclined to grant her a hearing request.
I had a very similar analysis.
Okay. Well, let me move on to the issues then. I would organize the issues that Ms. Warden raised as follows: whether the draft permit is protective of water quality, whether it adequately addresses stormwater runoff, whether it adequately protects against nuisance conditions, and whether it's protective of the health of Ms. Warden and her family. I'd also allow the full 180 days for the hearing, and I would include an ADR referral on this item.
I think I'm in agreement there. You described substantially the same issues I'd captured. I've marked protectiveness of water quality, the nuisance condition concerns raised, and also health of the requester and their family. So
okay, and did you have stormwater on yours?
Yes, water quality includes whether it contains adequate provisions to address stormwater runoff.
Right.
I think
okay.
It's subsumed in that.
Sounds like we may be ready for a motion.
I will move that we grant the hearing request of Monica J. Warden, refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrent with the SOA preliminary hearing scheduling efforts, refer the matter to SOA for a contested case hearing on the following issues: A, whether the draft permit is protective of water quality, including whether it contains adequate provisions to address stormwater runoff; B, whether the draft permit adequately prevents nuisance conditions, including odor and flies; C, whether the draft permit is protective of the health of the requester and their family. And finally, I'd move that we specify the maximum duration of the hearing is to be 180 days from the preliminary hearing to issuance of the proposal for decision.
All right, the motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by the City of Fort Worth for new Texas Pollutant Discharge Elimination System permit number WQ 0015668001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
So again, we have a two-part analysis for considering requests for contested cases. Part 1 is about who gets a hearing, and Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit, and have done so both in timely comments and a timely hearing request, are entitled to a hearing. For governmental entities, they can have standing if, in addition to meeting the other requirements, they have authority under state law over the issues raised by the application. And as to associations, associations can have standing if they name at least one member who would have standing in his or her own right, and they raise issues that are both germane to the organization's purpose and relevant to the application. So, Commissioner Janeka, on this item, we have numerous requests, and I'm going to begin with the easy one, and that's Martha Leonard. She's pretty clearly met the procedural and substantive requirements with respect to timely filings. She states that she owns property on the discharge route within a mile of the proposed outfall. She expresses personal concerns about water quality, recreational interests, wildlife. So I do believe she's affected in a manner different from the general public. Tarrant Regional Water District, a governmental entity, also met the procedural requirements, and it certainly has jurisdiction under state law over the types of issues that are implicated under the proposed permit. My question about the district is whether it could, in fact, be affected in a manner different from the general public. It appears that the district's interest in the Clear Fork is at their closest more than 7 miles downstream of the proposed outfall. And I think that if unless the district can show something more than that, I don't believe it can be considered an affected person, but I'm a little bit on the fence on this one. So to be clear, I think we should either deny it or perhaps refer it to SOA for an effectiveness determination. So let me just park that one for a moment, and I'll get your thoughts on that later. Moving on to the associations, we have several associations that requested a hearing. None of them identified a member who would have standing in his or her own right, so we're compelled to deny those. And there were several remaining requesters, all individuals who also, in my view, failed to meet the requirements, mostly by failing to show any proximity to the outfall or the facility. So I would deny those requests. So that's how I came out on the parties.
I think it was a well described analysis, and I think I'm in functional alignment. And I appreciate your description of the factor for that second party, Tarrant Regional Water District. As a governmental entity, I agree that they may be eligible as an affected person, but I reached the similar conclusion that it wasn't apparent to me in the record that they could be, and we could say it definitively. I feel that additional analysis they provided in their comments on it is something that would be appropriate to send before to so allow them to make that decision. And not to get ahead of us, but I think that's perhaps important for some of the issues that were raised by Ms. Leonard and by them.
Yeah, okay. Well, in terms of referring it to SOA, I'm really ambivalent, but I have no problem with that suggestion. So I'm fine seconding that in a motion. And I think what you're getting to on the issues is that Ms. Leonard preserved certain issues that are going to be in without any question. In addition to that, the district raised some issues that I guess will be contingent. We will refer them contingent on the district's status as an affected party. That's what you're getting at.
Exactly correct.
Okay. All right. Well, let me run through the issues then. I've identified the following issues that are relevant material, and these are as to Ms. Leonard's request. So these are referred, period, without qualification or contingency. And those are whether the draft permit is protective of water quality, whether it includes appropriate nutrient limits, whether it is protective of the existing uses in the receiving waters, whether it is protective of the health of aquatic and terrestrial wildlife, and whether it is protective of the health of the requester and her family. So, and I've had my coffee this morning, so I'm reading quickly, but are you able to track
followed.
those?
I think
Okay.
that captured the issues that I found that could easily be referred on, assuming that we agree Ms. Leonard is affected.
Okay.
She raised those.
So let me move on to the contingent issues. And again, these would be, we're referring these over in the event that SOA were to find the district to be an affected person.
Mhm.
And there are two additional issues. The first is whether the draft permit complies with the agency's anti-degradation requirements, and the second is whether the applicant substantially complied with the public notice requirements.
I found the same.
Okay. There were some requests for reconsideration. In my view, they did not raise new facts that might alter the ED's decision, so I would deny those. And I would again include an ADR referral and allow 180 days for the hearing.
I'm in agreement.
I think we're ready for a motion.
Excellent. I will venture forth. I move that we grant the hearing request of Martha Leonard, that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit is protective of water quality, including nutrient limits and the existing uses of the receiving waters in accordance with the Texas Surface Water Quality Standards. And Issue 2, whether the draft permit includes adequate provisions to protect the health of nearby residents and their families and aquatic and terrestrial wildlife. I move that we refer the hearing request of Tarrant Regional Water District to SOA for an effectiveness determination. If SOA finds that the Tarrant Regional Water District qualifies as an affected person in this matter, then refer to SOA the following additional issues. Issue 3, whether the draft permit complies with applicable anti-degradation requirements, and Issue 4, whether the applicant substantially complied with all applicable public notice requirements. I move that we deny all other hearing requests and requests for reconsideration. I move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process. And finally, move that we set a hearing determination of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
And you said hearing determination, but did you mean duration? On the setting the hearing duration?
I did. Thank you so much for clarifying.
Uh-huh.
That was hearing duration of 180 days. Yes.
All right. You've had your coffee as well.
Not quite enough of it, but thank you. Thank you, Ms. Smith.
All right. I think we're good. The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 3 is the application by AIRW 2017-7LP for new Texas Pollutant Discharge Elimination System Permit number WQ 001-587-8001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
So again, we have a two-part analysis, and again, part one is about who gets a hearing, and part two is about which issues are referred. And again, requesters who are affected in a manner different from the general public, who have articulated personal concerns that are relevant and material to the permit, and have done so both in timely comments and a timely hearing request, are entitled to a hearing. And again, governmental entities can have standing if, in addition to meeting the other requirements, they have authority under state law over the issues raised by the application. And Commissioner Ginecca, we have two requests on this item, both by governmental entities. and those are the City of Georgetown and the Jonah Water Special Utility District. The proposed facility and its outfall are both within the City of Georgetown's ETJ, so the city pretty clearly has authority under state law over issues raised by the application. In addition, I think the city has met the other procedural and substantive requirements to be entitled to a contested case, so I would grant its request. The district, however, failed to file timely comments, so we're compelled to deny its request. And I just want to see if there's any disagreement before I forge ahead.
None here.
Okay. All right. Well, the city preserved numerous issues, and I would organize them and refer them as follows. Whether the draft permit is protective of water quality, whether it is protective of the existing uses of the receiving waters, whether it is protective of aquatic and terrestrial life, whether it is protective of the health of nearby residents, whether it is protective against nuisance odors, whether it is consistent with the state's regionalization policy and demonstration of need, whether it complies with TCEQ's anti-degradation policy, whether it should be altered or denied based on the applicant's compliance history, whether the draft permit contains adequate operational requirements to ensure protection of water quality, and finally, whether the application is substantially complete and accurate.
I think you've named the operative words from each of the lengthy list of issues that I found the city raised as well. Thank you.
Okay, and again, the city requested a reconsideration of the ED's decision, but I think the issues raised have been addressed in its response to comments, and also involve factual disputes that are better handled at SOA, so I would deny that request. Okay, I think I'm ready to entertain any additional thoughts or a motion.
I'm in clear agreement, and so we'll just proceed with the motion I move that we grant the hearing request of the City of Georgetown, that we deny all remaining hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing concerning the following issues. A, whether the draft permit is protective of water quality and the existing uses of the receiving waters in accordance with applicable Texas surface water quality standards, including protection of aquatic and terrestrial wildlife. B, whether the draft permit is consistent with the state's regionalization policy and demonstration of need for the volume requested in the application for a new discharge permit pursuant to Texas Water Code 26.0282. C, whether the draft permit is protective of the health of the nearby residents. D, whether the draft permit complies with applicable requirements regarding nuisance odors. E, whether the application is substantially complete and accurate. F, whether the draft permit complies with TCEQ's anti-degradation policy and procedures. G, whether the permit should be altered or denied based on the applicant's compliance history. And H, whether the draft permit contains sufficient provisions to ensure protection of water quality, including necessary operational requirements. And that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
The next item is our enforcement docket. It's old business item 1 and new business items 4 through 24. The executive director's staff is here to present these matters.
Good morning. And Ms. Cordell, if you're presenting this morning, I can't hear your voice. You might check your mute button.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. Can you hear me?
Loud and clear.
Thank you. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Beckins of the Litigation Division, representing the Executive Director. Pending before you are Old Business Item 1 and New Business Items 4 through 24. The total assessed administrative penalties are $315,495, with $36,523 deferred, $98,411 applied for supplemental environmental projects, and $180,561 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none at the moment. Commissioner Janeka, any questions?
None. Thank you.
Okay, we do have a few people signed in, and these are all on old business, wishing to speak, all on old business 1. And let's begin with Alessandra Papa. Good morning.
Good morning, Commissioners.
Check the microphone, make sure that the light is on there. Do you see the light on? Should
Yes,
be green.
the light is on.
Okay. Go ahead and identify yourself and go ahead with your comments.
My name is Alessandra Papa. I am a student attorney with the UT Environmental Law Clinic, and I represent Ms. Angel Machuca of Toya, Texas. Today's agreed order or enforcement order is for a failure to submit surface water and total organic carbon monthly operating reports. And the ordering provisions appear simple. Start submitting these reports within 30 days or within the first quarter, respectively. However, this is actually no small feat in Toya. They received an enforcement order in 2019 for the same violations, but that is still open. That and 2 other open enforcement orders show that these provisions are not enough to bring the city into compliance. Many small towns struggle to meet technical requirements because of a lack of funding, a lack of qualified contractors or tradesmen in the area, or a simple lack of licensed operators in the area. These are not the problems in Toya. First, the city does not lack funding. They've received a $200,000 grant from the Texas Water Development Board, and they have chosen not to request additional funding, even though they have qualified for several years. Second, they have undergone other construction projects in the city while the water plant has languished, so this shows that they do not lack contractors or tradesmen like electricians that they need at the water plant. Third, a licensed water operator has submitted a written offer to the city to oversee their water plant, and they have not hired him, and surrounding towns do not appear to have the same struggle to find a licensed operator. Toya warrants a closer look. The citizens deserve clean drinking water, and they deserve transparency about the quality of their drinking water. City Council meeting minutes, all the way back to 2019, appear to suggest that the water plant was actually complete and only waiting on about a week's worth of valve replacement or pipe work. That's just one example of the citizens being led to believe that the water plant will be open soon. Soon never seems to come. In addition to the ordering provisions today, the city should be required to submit a written report to TCEQ that is publicly available that details concrete next steps, deadlines for completing those steps, and real consequences should they fail to meet those steps. In addition, we would ask TCEQ to assist us in locating funding for temporary water filters for the citizens who have been on a boil water notice for over 3 years. Thank you for your attention this morning and for helping us bring clean water to Toya.
Thank you, Ms. Papa. Any questions, Commissioner Janeka?
Not right now. Thank you.
Thank you. Appreciate you being here. We also have Joseph Hughes signed in. Are you there, Mr. Hughes?
Yes, I am. Good morning.
Good morning.
So thank you for the opportunity to address you again on the situation in Toya. My name is Joe Hughes. I'm a student in the University Environmental Law Clinic, also representing Angel Machuca, a citizen of Toya. In light of what Ms. Papa just said, I will only add the larger picture that Toya has been under this boil water notice for 3 years, is relying on unapproved filters, and does not appear to have a properly licensed operator to administer the system. And this situation has persisted despite repeated enforcement orders from the TCEQ. I raised the same issues that Ms. Papa raised, that, there's been a continuing communication that the plant will be fixed soon, but that never seems to happen. And just to clarify, our request is for transparency and follow through. We ask the residents of Toya receive details on what the plan actually is to fix the plant and firm binding deadlines to have the plant back into service. This information should be publicly available and the process should be monitored closely by the TCEQ with some certification that the work is being done properly. Additionally, we asked for more serious penalties if the city again fails to meet its commitments. Thank you again for the chance to bring up these issues, and as always, we hope to be able to work together to get clean water in Toyah. So thank you very much.
Well, thank you, Mr. Hughes. Appreciate you sharing your thoughts and comments with us this morning. Commissioner Janek, any questions?
Thank you, and no questions right now.
Okay. I understand we also have Naomi Machuca, Mayor Pro Tem for the city of Toyah, on the line. And Ms. Machuca, if you're there, I'm interested in hearing your response to the suggestions or requests by Ms. Papa and Mr. Hughes. Are you with us this morning? And you might double check your mute button if you're there, because we can't hear you. It sounds like you cut
Hello?
in. You cut in and out just very quickly. You want to try that again?
Can you hear us now?
I can hear you now. Great. Were you
Yes,
able
sir.
to
I would like to.
go ahead?
Yes, I would like to disagree with the first speaker as far as talking about us having contractors work on other projects. First of all, on our budget, those projects are separate from water, and every dime we had that was for the water project was used in together with the grant that we got. That grant is still not even completed. We have been working. We do have a licensee operator who's going to school to get her B license also. And so it's not like we're not doing anything. And the funds that Toyah makes right now, or has ever made, is too hard to keep a B licensed operator on payroll. But I have my licensed water operator and our grant liaison with us, and they'd like to say a few words really quickly also.
Sure. Thank you. And I'll ask them just to identify themselves. Tell us their names, and then go ahead with their comments.
Okay, to start with, my name is Ed Puckett. We are completing the project on the water plant in-house. We could not afford to pay the contractors, and they walked off the job. So as of yesterday, we had reached the point that we have gotten approval on our water samples. The plant is being turned back on today for the first time in about 3 years. I wrote the grant. We got $200,000 from Texas Water Development Board. In that project, we went from $200,000 to almost $468,000 of additional repairs. We have spent every dime that Toyah had available for the water plant. The idea that we did other things with the money is not true. We did not have money available for the water plant to do anything. This town has 30 connections. You're asking almost $1,000 per connection in fines. The average income in this town is $9,000 per household. There's no way that we can afford to pay any kind of fines when the money needs to go to the repairs of the plant. Now, additionally, the SWMORs we will be able to do them because now that the plant is back on, we can take the readings that are necessary.
Well, thank you,
I should be
Mr.
able to. This is Brandy. I'm sorry.
Oh,
Brandy
go-
Baker, so water operator, Class C. I have one more class to take, and I'm probably going to sign up in December for it to be able to test for my B. As Ed said, it's correct. We are turning our plant on today. I have did the 24-hour shock on the filter last week and sent in samples and got back samples that were negative and good to go to actually process water through my rapid sand filter. and that's what we are doing today.
All right. Well, thank you, Ms. Baker and Mr. Puckett.
Okay, this is Ed again. I have one more.
Yeah, please go ahead.
To say. It was mentioned that more money was available to us. That is not true. We lost our CPA due to internal strife and trouble on the city council. The CPA quit. And in the process of quitting, we lost our ability to be able to get audits. You cannot get a grant from Texas Water Development Board without an auditable set of books. So right now, we are currently looking for a new city secretary to try to get our books caught up so that we can be audited. But at this point in time, there is no money available to the town.
The problems that you're describing are, I think, probably familiar to a lot of small water systems in Texas. Texas has over 7,000 public water systems. Most of them are very small. The system that you describe with 30 connections is not unusual. Just the economics of it, as you're describing, are not unusual. They're familiar to us. There are not enough connections to charge the rates that will cover the freight for all of the compliance activities. Or let me not say that it's impossible. Let me just say that it's, because I'm an optimist, I'll just say that it's very, very challenging, and the problems are familiar to us. It does sound like you're making some real progress. I think, in terms of was the $200,000 spent or not spent, my view is that government budgets can be very difficult to understand and sometimes impenetrable. And I trust that you're using the right color of money, as we call it around here, for the right projects, and that you're meeting the requirements for spending of grant funds on projects authorized by grant funds. So that's not an issue for me. I think, Commissioner Ginecca, where I am is I want to, I think I want to give the city an opportunity to prove it up. It sounds like they're right on the cusp. They've got water samples. They're turning it on today. Just see how it goes. I understand there's another enforcement action pending. Not relating to reporting, but to more substantive issues. And I think we'll have a chance to have this conversation again, particularly if Ms. Papa and Mr. Hughes are not satisfied with what they're seeing on the ground. They can come and visit with us again when that one is on the docket. Let me just set that aside for a moment and invite the executive director and OPIC to share any thoughts to the extent that they have developed any. So is there somebody from the executive director's staff who would like to add any context or comments at this point?
Chairman, if I might ask right now, before ED staff weighs in, one question that I had was in particular about the prospect of cities to utilize penalties rather than paying them to our agency to go into state coffers. They may have an ability to utilize those penalties to do a compliance step where they apply it directly to their projects. And I wonder, and I would only hope and ask if there's been any discussion, or maybe they are easily eligible or ineligible from ED staff. If you have something to say on that, please feel free to chime in. Otherwise, I'm trusting that y'all will be able to lead them to that point on future enforcement matters. So that said, thanks. ED staff, please go right ahead.
Good morning, Chairman, Commissioner, and General Counsel. This is Susan Jablonski of the Enforcement Division. And, Commissioner Ginecca, to address your questions, because of the fact that they have an order on the record, they are ineligible for that compliance step as it sits now for the current fine. Now, we would have that consideration with any future orders as well, and look at the things that will be into consideration of whether they could potentially have the compliance step in the future. So we will definitely make sure that that opportunity is communicated to them in any future order should they be able to avail themselves of that. We also have David Ramirez with us in the room that can speak to what has been happening out in the field in the contact with our regional office, if y'all would like to hear from Mr. Ramirez.
Very much so.
I would. Thank you. Good morning, Mr. Ramirez.
Good morning, Chairman. Good morning, Commissioner. Good morning, General Counsel. For the record, my name is David Ramirez. I'm the Border and Permian Basin Area Director. And as Susan mentioned, the region has been utilizing quite a bit of resources since 2018. We've conducted approximately 25 investigations for this site. So they are definitely something that we are monitoring and tracking. And it was good to hear that the city is activating the plant today. And from a regional standpoint, we will certainly work with the city to provide any technical assistance, but also monitor their current progress to ensure that they're meeting the minimum standards that we would expect from a fully operational plant. I'm open for any questions or comments you may have.
Thank you. No questions from me, but I appreciate your comments, Mr. Ramirez. Commissioner Janeka?
I take a lot of comfort hearing that update, Mr. Ramirez. Thank you so much, and please do continue your efforts on this.
So thank you, Mr. Ramirez. Thank you, Ms. Jablonski. I wanted to give the Office of Public Interest Counsel an opportunity to offer any comments to the extent that you've looked at this item. Mr. McWhorter, are you there?
Yes, sir, Chairman. I agree with the approach you outlined in your comments, especially after hearing from the city and Mr. Ramirez today. I think the best approach would be, in my opinion, would be to move forward and watch and see what happens and hope that we are on the right path.
Thank you, Mr. McWhorter. A couple things I want to mention. Number one, I just want to give a plug for the agency's resources. I think the city is probably well aware of these by now, but the TCEQ has a small business and local government assistance program that can offer advice and guidance on compliance issues. We also have a really outstanding team of experts. We call them our TOPS team, who are skilled at making water systems run correctly. And they've been fantastic in responding to hurricanes and other disasters and just helping systems that are struggling solve technical issues. But that's really just an advertisement. I'm assuming that the city is already well aware of those resources. Separately, I'd like to encourage, this is for Mayor Pro Tem Machuca. I heard from the commenters, some concern about transparency and being in government. It's important. You never can have too much of that. To the extent you're not already doing so, I might encourage you just to set aside a section of a few minutes during your city meetings just to provide a quick report or update on your activities around the water system, just so the residents can actually hear and understand that you are working on the issue and have a sense of the challenges that you're facing and the progress that you're making towards overcoming those challenges. Certainly nothing in the way of an order, just a thought or a suggestion. Commissioner, I think I'm ready to move forward and approve this, and just, we'll have another bite at the apple when the other enforcement order comes across, and I think we'll know a lot more then about how the city is progressing. So
I appreciate that. I have only one final thought to add, and I'm with you. I'm ready to proceed as well. I just wanted to thank the Mayor Pro Tem and city staff for providing the comments today, and particularly Ms. Baker. I think that hearing from you helps give me a lot more confidence, a much better idea of the level of seriousness the city is applying to operating the plant. Turning it on, I think, is great news, and I just wish you luck on your test, your final test or final class, and getting across that test on the Class B. I know that's something that the state can never have too many of, so thank you and congrats and good luck on the work ahead. But good to proceed.
Thank you.
Thank you, sir.
Yeah, thank you. Ms. Smith, anybody else signed in to speak on the enforcement docket?
No, we have somebody signed in on 10 who's available for questions, and their presence will be noted for the record.
Okay, and Mr. McWhorter, what are your thoughts about the remainder of the enforcement docket?
OPIC reviewed the items on the remainder of the enforcement docket, and we recommend approval of the orders as presented by the executive director.
Thank you, Mr. McWhorter. I appreciate that. I wanted to, before I forge ahead, just take a look at some notes here. For Executive Director staff on item 14, it's KBB and KBB Incorporated, DBA Crossroads, Conoco. This is a PST agreed order on a petroleum storage tank enforcement order. And my concern there is that the violation is of a previous order, and so it indicates an indifference to a known legal duty. I'll invite you to speak to that item if you'd like to. I don't have any specific questions, but just a request that our Office of Compliance and Enforcement keep close tabs on that one. And let me pause for a moment and invite any comments if you have any.
Chairman Neerman, this is Charmaine Backens with the Litigation Division. I am aware of the previous order. In fact, I have a copy of it, and I'm refreshing my memory as I speak. It's for failure to provide corrosion protection, release detection, and maintain records. So I am aware of that. We can, of course, work with the Enforcement Division and order compliance monitoring and closely watch this. And if this respondent doesn't respond to our administrative efforts, we can explore the possibility of civil enforcement if they do not comply. Does that address your concern, Chairman?
It does. Thank you, Ms. Backens. I appreciate that. Commissioner Ginecca, do you have anything on that?
I appreciate you asking the question, Chairman. I'm going to just stumble right into this as well. And I was reviewing my own notes right at the moment that you raised the question, considering whether I wanted to ask it as well. And frankly, I was, at the moment in time, I'm taking it by its presence on the agreed docket that ED staff have got enough forward momentum from this respondent at the moment. And I note that there are some increased penalties that they will pay the state as a consequence of apparently ignoring the previous order. So I appreciate you voicing, and I echo that encouragement to ED staff to watch this item closely. Thank you, Ms. Backens, for the update on it. Never an encouraging set of facts to see on it, so I appreciate the little extra detail.
Thank you, Commissioner. I'll just share a public service message based on my experience before coming to the TCEQ at the Attorney General's office. My problem is I'm not talking to the right audience, but we saw again and again, and unfortunately it was usually smaller, less sophisticated operators who, for whatever reason, were not paying attention to the notices, did not take the actions by the state seriously, and small problems that would take hundreds of dollars to fix, small administrative penalties just due to lack of attention would grow and grow, turn into multiple orders. And I beg of the regulated community to please pay attention and try to solve these problems before they get big, because once they get over to the Attorney General's office, there's really not a lot of latitude to work with them. So it was frustrating for me to see that. So anyway, so much for the public service announcement. I'm not sure anybody who may be affected by it could be listening, but I wanted to share that. Commissioner Ginecca, there was another item on here, item 7, the TPC group, that gave me pause. And this is another case where there were, this is more violations on top of existing violations and orders. And really on that one, I would like to hear from TPC group and get some comfort around their plans to to solve this problem and not have the same violation show up on our docket. So I think I'm going to get your thoughts, but maybe suggest that we continue that item and invite somebody from TPC group in to let us know what they're doing to get right with the regulations and not continue to show up on our docket with the same violations.
I sincerely appreciate the suggestion, Chairman, and I don't think that I'm disinclined to agree with you on it. I think I defer heavily to you on the relationship and posture with that company. There were some serious missteps at a different site that they're responsible for just before my time in coming into this role, and so I take seriously the close scrutiny that we need to apply. And in all manner, we're engaged with this entity at this time. So I'm not opposed to that whatsoever.
Okay. I don't have any particular objection or concerns about the order itself. It's just that they're reappearing again and again. I trust that they have a solution. I just like to hear some more about it on the next agenda.
So would you propose that we, on item 7,
continue that item to the next agenda?
Perfect.
Yeah. All right. That's all I had for the enforcement docket.
I think, is that, Ms. Smith, can we do that in a separate motion to continue item 7, or should I do that in the same motion with the rest of the enforcement docket?
You can do it in the same motion.
I'll do my best. I will move that we adopt old business item 1 and new business items 4 through 6 and 8 through 24 as recommended today by the executive director, and that we continue item 7.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 25 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Sections 335.323 and 335.325, related to increases in industrial and hazardous waste generator and management fees. The executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Garrett Heathman with the Waste Permits Division. With me is Charlie Fritz, also with the Waste Permits Division, and Audrey Leiter and Jesse Spears with the Environmental Law Division. This adopted rulemaking would amend 30 TAC Chapter 335 Industrial Solid Waste Municipal Hazardous Waste Section 335.323 and Section 335.325 relating to waste generation and waste management fees. The proposed rules were published in the June 4th, 2021 issue of the Texas Register. A public hearing was held on June 29th, 2021. The public comment period closed on July 6th, 2021. The rule team did receive public comments, and based on those comments, the rule team made the following substantive changes. The executive director added language regarding notification of fee adjustments, revised titles and figures to increase clarity and consistency, and added language to preamble to include a phased fee increase for both generation and management fees. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 335. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you. I have none. Commissioner Janeka, any questions?
Not at this time. Thank you.
Thank you. Ms. Smith, is anyone signed in to speak?
No one signed in on this one.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC recommends adoption of the amendments to 30 TAC sections 335.323 and 335.325 regarding industrial and hazardous waste fee schedules as presented by the executive director.
Thank you, Mr. McWhorter. I agree. And Commissioner Janeka, as you know, we've got a declining fund balance in our waste account, and so we need to act. I think that the proposed step is certainly reasonable. I'm not convinced that it's the optimal solution, and I'm certainly open to future rulemakings to get closer to an optimal solution if we can identify such a thing. But in the meantime, I'm in favor of moving forward with adoption.
I appreciate that, and I think that one point of nuance here that I really wanted to zero in on and just encourage executive director staff to pay close attention to in the implementation is the impact of agency fee numbers, changes of those fees, how they may translate into the resulting universe of activities upon which those fees are collected. And I think this is a point that I take very, very well in hand in terms of having seen it in my prior public policy experience, where other state entities could point discreetly to customers choosing whether or not to send wastes or to engage in business in Texas because of state fees or state dollar requirements tacked onto that transaction of doing business in Texas. And when our agency's much needed update to this fee, these particular sets of fees in our rules, as we're taking this step here today, we're running directly up into this public policy potential, and I would call it a pitfall. And I just want to applaud ED's proposal to engage annually in that change, that true up. And so I hope that this becomes a conversation we have with stakeholders, and that includes both the customers who produce these wastes and pay these fees, and also the brokers and entities and industry who may have to collect the fees and remit them to us, because understanding how it impacts their business, I think, is really critically important for us. I would hate for us to miss that message if it was coming back. TCQ, you need to collect enough dollars to cover your costs, but if you raise this fee, that pie will shrink and your dollars will come in. I think that the executive director staff proposing to give a phased-in fee change schedule here and preserving an ability for them to adjust that fee annually, it is two really important pieces, and I'm eager to hear how this conversation plays out in public space. So thanks for the changes. Thank you to the members of the public who provided their concerns and cautions to us about how the change may impact their business and thus our fee collections. I really look forward to us continuing this conversation and understanding how those changes will impact you and how it impacts state revenue. So thank you all.
Very good point. Appreciate it.
And I guess
I think we're ready for a
do
motion.
you hear everybody else? Yeah,
Yep.
I will finally conclude, wrap up, and
Oh,
move.
you know what? I don't think I asked. Did I ask Mr. McWhirter about his thoughts on the rulemaking? Okay. I've lost track. All right. So I think we're good.
Hard
Please
not
go
having
ahead.
the faces to connect with the conversation at the moment. I move that we adopt the amendments to 30 Texas Administrative Code Chapter 335 as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
The next item is our public comment session. Currently, we don't have anyone signed in to speak, but we will pause and allow the line to be unmuted so that if there's anyone that wishes to speak, they can. Hearing none, we will move along to the next items, which are 27 through 30, and these are posted for closed session. The commission will not meet in closed session today.
The time is 10:23 and we are adjourned.